Okay. I'll be around the rest of the morning, well, the rest of the day actually. So if you have questions that come to you while I'm here, you're welcome to stop me and pull me aside. And I think the schedule is that we take a break now from 11:15 to 11:30, and then come back at that point.
If I can say one thing, I know you're going to run up and run to the restroom, but I want to point out in the packets that you have, we were talking about forms today. There is a CD that has a copy of the appellate manual that's been put together by Jim Bonner, and also a copy of an appellate manual that's been put together by Robert Purse. Those are valuable materials for you to take a look at. You'll see forms, you'll see timelines, you'll see narrative that will explain different things in the appellate process that will supplement what you hear today. It's a process of learning. And we know by the show of hands earlier that most of you have not done criminal appeals, but that will help you greatly. So please take a look at that in addition to the printout material that you have in that packet. And we'll see you back in your seats at 11:30.
Yeah, let me just add this quickly. The outline that's mine on the CD is what happens if you're the trial counsel and you lose and you have to handle the appeal as well. And I was telling Trish earlier, I'm going to supplement the materials at some point, at least at the central office, with what happens when somebody else has tried the case, and then you're basically hand the file as the appellate counsel and include the points that I was talking about.
Which is going to be tricks of the trade, spotting and choosing appellate issues. We talked a lot this morning about the mechanics of how you move a case along, where that case is going to end up at the Superior Court, at the Court of Appeals, at the Supreme Court. And we've touched a little bit on ineffective assistance issues, which we'll deal more in depth later on. But what we're going to move into now is what you actually do once you get that transcript, once you get the record of the case and you start looking through it. How do you identify the issues that are going to be viable at the motion for new trial and on appeal? To help us do that, we have another panel of esteemed colleagues that includes Chris McFadden, whom you heard earlier, as well as Jim Bonner as facilitator, and you've already heard a lot about him. In addition, we have Cindy Wong, who works with me in the appellate division. You have her bio in the handout that you've been given, and also Mr. Steve Phillips. They all bring a differing yet and unique perspective to how to spot and choose appellate issues, how to vet those issues, and then how to elaborate on them so that you can get the most bang for your buck when you're arguing to the court. So with no further ado, I present to you tricks of the trade, spotting and choosing appellate issues.
Hello. I'm going to start because my role here today is basically to be a cheerleader for you guys. Not too long ago, I was in your position. My legal career predominantly, prior to being transferred over to the appellate division, was civil, and I did most of the policy work. So criminal appellate practice was completely new to me when I transferred over to the appellate division. As you can see from my bio, I'm the senior staff attorney because I'm the only full-time staff attorney under Ms. Rogers. And of course, we fortunately have Jim Bonner with us still, because I can't do my job without Jim. I mean, he's just phenomenal. Anyway, so I told Steve and Jim today that I'm just going to be the Rob Schneider character in Waterboy. You can do it. I mean, you can. I know it's a daunting task to look at, especially a multi-volume trial transcript, to come up with issues. And you're going to come to that point where after you read that transcript, you're going to be like, I didn't see anything. Did I miss something? And a lot of times you are going to have trials that were just cleanly tried. And there's not going to be that many issues, and so what do you do? Jim and Steve and Chris are going to talk about that too, the substantive portions. They'll mention that, I mean, obviously in Georgia we can't file Andrews brief, so we have to come up with something. And a lot of times, we'll raise insufficiency of evidence. And the way I kind of approach it when I'm trying to come up with the issues, when I'm writing the brief, if I can't seem to make my fingers type it, then that's not a good issue. Jim has the laugh out loud test. That if you actually can write it without laughing out loud, you know, you can write it. But yeah, but you really can come up with issues. There is always insufficiency of evidence. And you look at all the court errors, and Steve's going to talk about digesting a case. I don't think that was really covered during the first part. But when you're digesting cases, when you're first spotting the issues and really going through that, I wanted to just give a couple of practice pointers. Tom had mentioned this earlier too about reading the new cases because you get ideas for issues. A lot of times you may want to raise venue charges and given, or if there was an edge problem, whatever. But if you look at the cases, you kind of get an idea of what type of issues to look for. Tom also mentioned what's the decision that is put out by GACL that always has it sets it up with based on issues of how the Supreme Court and the Court of Appeals rule, and sometimes you have some federal cases in there too. I wanted to mention, I know Gerard takes copious notes when he reads a trial transcript. In my case, I take a lot of notes when I'm digesting a trial transcript, but there are portions of the trial transcript that I want to go back and review more than once. Preferably, I like to review the whole trial transcript over again, but a lot of times you're constrained by time. So there's particular portions that you really need to pay close attention to, and that includes like jury instructions, because chances are you're going to a lot of times find your issue in the jury instructions. And Robert mentioned this in the first session, that you want to check the records to make sure that those jury instructions are in the record. If the defense requested it, and if there was a problem with it, then you're going to have to raise an effective assistance of counsel. So you want to make sure that all that is in the records. A lot of times, I mean, like I mentioned before, I can't do my job without Jim. And in my 2 years that I've been with the division, I've had some appellate successes. Due to in large part to Jim Bonner and Jiminique Rogers. When you're kind of new at doing this, you rely a lot on the people with a lot of appellate experience. And so, please feel free to call upon us if you have a question, or if you particularly want to vet an issue. We often have these case discussions where we talk about a case, and we'll go, okay, well, what do you think about this particular issue? Is that something that I need to spend more time on, or things of that nature. So, with that being said, I'll turn to these learned professionals, or Steve.
I'm going to talk about pretty much what I do when I get a case, and how I start out thinking about it and trying to go through it. I'm sitting at my desk. I've generally got a transcript that could be anywhere from 500 to 4,000 pages in front of me. I've amassed as much as I can from trial counsel. If I can get his trial file, that's great. I've had cases where, I have a case that I'm working on now where trial counsel's trial file was destroyed in a flood of his office, so we don't have that. I'll get the trial file, I'll get the discovery from the clerk's office. So I'll have police reports, witness statements. If you're getting cases from Fulton County and it's a large case, now they've started doing pretrial witness interviews. They'll develop, they'll have a big interview of the witnesses that they're using, and they'll have transcripts of these witness interviews. So I may have extra transcripts of witness interviews as well. And I've got all this material in front of me, and what I'm trying to do with it is I'm trying to get a sense of how strong this case was for the state. And the reason I want to do that is because finding a mistake or an error in the transcript is not going to be enough to make a good issue. There's two parts to every issue, to every winning argument, and that is finding an error, and also finding an error that's harmful, that is, it had some sort of effect on the outcome of the trial. And depending on what the category of error is, you're going to have different standards for assessing the harm in the context of the trial. So I really want to try and get a feel for, is this a case where it was a close case? Was this a case that relied on one key witness for the state? Was this a case where my client shot somebody in a public place and there are 14 witnesses who've known him since he was 5 and they're all identifying him? Okay, because that's going to, depending on how strong the case is for the state, that's going to sort of start my thinking about what kind of issues are likely to work in this case. And so, again, talking to trial counsel, talking to the client, going over the discovery are good preliminary steps to sort of get a little grounding about what this case is about and how strong it's looking for the state before you even start diving into the transcript. You have a sense of where it's going. Once I've done that, I'm going to get the transcript and crack it open and start reading. And there may be pretrial motions that are always good sources for issues. Any adverse ruling can be appealed. It's going to be jury selection, which is again another good source for potential issues. And then there's the body of the trial itself, where you have the evidence, the opening, closing statements, the jury charges. And when I'm reading a transcript, and I think they may have touched upon this in the first segment this morning, but one of the most important things that I do is I do what's called digesting the transcript. That is basically detailed note-taking of what I'm reading, where I indicate page numbers. When something happens that seems significant, I'll take copious notes on that particular issue. And if there are issues that I spot, for example, there's a hearing about, pretrial about whether similar transactions are coming into evidence, and I'll note where that happened. And I have my own method of highlighting it so I can see this is a potential issue. I'm not deciding at this point whether it's going to be an issue. I'm just trying to be over-inclusive from the start. That is, anything that smells like an issue, that looks like a potential issue, I'm going to flag it and then develop what would be later like a master list of potential issues, and then I'll start whittling it down from there. I had a note about, don't dismiss your client as a source of potential issues. Sometimes things happen that are not reflected in the record. Your client was at the trial. You weren't. And so your client or your client's family can be important sources of information. Now, granted, sometimes there's a lot of sifting that has to go on because your client may want to talk about a lot of things that he perceives to have been unfair, that really have no relationship at all to any sort of issue that's ever going to have a chance of prevailing on appeal. But in those initial phases when you're talking about the case, the best thing you can do is just to listen. Because if you sift through all the extraneous stuff, every now and then a nugget's going to come out. And if you dismiss your client from the get-go and you're not listening to him because he's not making a lot of sense, you may miss that nugget and you may miss your chance at something that's going to reverse the conviction. So from that point, digesting the transcript, taking notes, identifying issues, that's the initial stages of what I do. And like I said, I generate the master list of issues, and I'll work back from there.
And if I could add, Steve, basically the way I approach digest is that this digest is going to help me draft the brief. And so